Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hockman, LLP, a premier litigation and art law boutique in New York City.
Hi, Katie.
Hi, Steve.
We are here today to talk about some exciting developments or
shocking
developments in France. And as it happens, I was in Egypt in late May visiting my daughter, and I heard the startling news that Jean-Luc Martinez, the former director of the Louvre from between 2013 and 2021, was charged with money laundering and fraud in connection with the illicit trafficking of Egyptian antiquities that were acquired by the Louvre Abu Dhabi. And today we're going to hear from French lawyer Sarah Arpagaus about the allegations against Mr. Martinez, and I'll introduce Sarah in a second. But I thought a little bit of background about the problem of illicitly trafficked antiquities and Egypt's particular 1983 patrimony law called Law 117 might be helpful for our listeners to put this discussion into context. So after World War II, there was kind of an explosion in illicit trade in cultural property, and eventually it was clear that there needed to be an international solution to this growing problem. So in the 1960s, UNESCO began drafting a new international convention, which resulted in the 1970 UNESCO Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property. Sometimes this is just called the 1970 UNESCO Convention. Eventually, over 100 nations signed on to the convention, and it took 13 years for the U.S. to pass enabling legislation in the form of something called the Convention on Cultural Property Implementation Act, or the CPIA. Now, I don't want to get too far into the weeds, but it's important to try to understand this. The CPIA, which is the U.S.'s way of kind of recognizing the 1970 UNESCO Convention, or at least putting it into practice, is a civil law, and it's part of our customs law. And it generally prohibits the import of cultural materials either identified as stolen from an institution in another party state, and it also allows the U.S. to apply controls for materials that are specifically identified by another party state that are in danger of being pillaged. And the remedies for a violation under the CPIA are traditional customs laws, namely seizure and eventual return of seized materials. Important to note that this is not a criminal law. It's a customs law. Now, going back to Egypt for a second, because of its rich history, Egypt has long been a target of international trafficking of its cultural patrimony. So at about the same time as the U.S. was implementing the 1970 convention, Egypt passed a law called Law 117. And Law 117 is Egypt's so-called patrimony law, which essentially states that all antiquities found in Egypt after 1983 are owned by and are the property of the Egyptian government. They can't be owned by an individual, an institution, they can't be exported. Other countries, so-called source nations, have patrimony laws as well, and we spoke recently about the Ottoman-era patrimony law, under which Turkey claims ownership of cultural property that came out of the ground in Turkey after 1909. And it's important to know that Egypt has enforced Law 117 within its own borders, and the penalties are both monetary and also penal. You can go to jail in Egypt for violating Law 117. So patrimony laws like Law 117 differ from the 1970 Convention and export laws that many nations have. France, for example, has export laws which essentially require you to get a license if you want to export art of a certain age and national importance. If you want to take a Monet water lilies out of France, you have to apply for a license. And either the French government will decide that the work is too important to leave the country and purchase it, or grant a license. But importantly, France does not assert ownership, but just simply says that you cannot remove it from the country without a license. Historically, the United States has not enforced the export laws of other nations. If you take a work out of France without a license, you face consequences in France, and you certainly face consequences within the art market, but the United States is not going to enforce that law here. And the difference between these two types of laws is important, the difference between patrimony and export laws. And this was illustrated most clearly in the case of the United States versus Frederick Schultz. Now, Mr. Schultz, who was a successful art dealer in New York, and his English co-conspirator, Jonathan Tokely Parry, arranged to smuggle into the U.S. for sale sculptures that were illegally excavated and removed from Egypt in violation of Law 117. What Mr. Schultz and Mr. Parry did was essentially take these cultural artifacts, paint them, made to look like cheap souvenirs, and then exported them out of the country. Mr. Schultz was eventually charged and ultimately convicted of one count of conspiracy to receive stolen property under the U.S. National Stolen Property Act, a federal law originally enacted to go after organized crime where stolen property was being transported across state lines. The U.S. government and the U.S. attorney in the Southern District put two things together. They put together Law 117, which basically said that Egypt was the owner of this property, and a U.S. law which prohibited the transportation of stolen property. And Mr. Schultz was ultimately convicted and went to jail. Now, Schultz, in his defense, argued that the U.S. doesn't enforce export laws, and that the Egyptian government never actually really owned these works. I mean, the fact that they were asserting ownership was somehow different than whether the works were actually in an institution, say, in Egypt. And so therefore, according to Mr. Schultz, they could not have been stolen. Ultimately, a federal court in New York disagreed with this argument, and a jury convicted Schultz, who went to prison. So, of course, these laws and the enforcement of these laws never really diminished the demand for Egyptian antiquities. And in the wake of the Arab Spring in Egypt in 2011, the supply of those antiquities to the marketplace increased.
And of course, Steve, European countries have their own ways of dealing with these cultural property issues and issues of repatriation. And today we're going to talk about one example in France, where France is using its much more traditional criminal laws to both go after and return objects and punish wrongdoers who have allegedly either stolen or trafficked in cultural property that originates elsewhere.
And here's where Mr. Martinez comes in. And here's where our guest comes in. So we're joined today by Sarah Arpagaus, who is both a French lawyer who studied law at the University of Paris and received her master's degree in law at the University of Paris, and then came to the United States and got her LLM at Duke University School of Law, and is admitted to the bar here in New York, as well as in Paris, where she is a practicing attorney and, among other things, is involved in both civil and criminal litigation in France. So thank you for joining us on the podcast today, Sarah.
Yes, Steve. Thanks for joining us.
All right. Well, Sarah, can you tell us a little bit about what's going on in Paris with Mr. Martinez and a little bit of the background and what he's been charged with?
Well, Steve Martinez, as you said, headed the Louvre between 2013 and 2021, and he is currently under judicial supervision.
And what does that mean? Does that mean he's under arrest or he's under house arrest?
He's under house arrest, and at any point he can be put into custody.
And are we right to say that he is the first director of the Louvre to be arrested in France, or is this more common than one would think?
No, he's the first director of the Louvre to be arrested. So basically the case was opened in 2018, 2 years after the Louvre Abu Dhabi purchased 5 ancient Egyptian artifacts, including a very rare pink granite stele of Tutankhamun for several million euros. And since then, the investigation has been going on, and 3 people have been detained and charged besides Martinez. So, of course, Martinez is the center of the investigation, but many people acted with him or helped him selling this very rare antique to the Louvre Abu Dhabi. Actually, the inquiry conducted in France by the investigating judge called Jean-Michel Gentil led the police taking Martinez into police custody on May 23rd, 2022. The investigators suspect that a man called Christophe Kunicki, an art dealer, and another man called Robin Dieb, a German Lebanese art dealer, have produced false documents and invented false origins in order to launder hundreds of objects looted in different countries in the Near and in the Middle East. And Robin Dieb might have helped broker the sale, and he was arrested in Germany and then extradited to Paris in March 2022.
And how do these kinds of investigations work in France? Because I know they're different. They work differently than they do in the U.S. You say that he was taken into custody. What's the process by which that happens?
So first of all, the police starts an investigation and they gather a lot of evidence. When the police thinks that they have enough evidence to hear, at least as a witness or as an accused person, they arrest someone. In this case, they arrested Martinez, and they took him into custody in order to hear him during 24 hours and asked a lot of questions. During this custody, Martinez called his lawyers, of course, because he has the right to an attorney during this custody. And he stopped answering the questions. At the end of this custody, he was released, but he was placed under judicial supervision, meaning that the investigation is still going on and the police is going to keep working on the case and is going to keep gathering a lot of evidence in order to Martinez to stand trial. But the investigation might take a lot of time.
Like years or something.
Might take years.
So, Sarah, is there some standard before, like Jean-Luc Martinez gets charged? What is the standard? I mean, here in the US, we have hundreds of years of jurisprudence to protect criminal defendants through due process, right? And that's obviously very different in France. But what are the standards before you can be charged? Or is it just some investigating judge thinks Jean-Luc might have been involved in this trafficking ring, and so he has to go to trial? Or is there some sort of check or evidence standard?
Now, as you said, Katie, there is also in France a due process, but it's a bit different from the US because the investigating judge has a lot of power in France. So he's the one in charge of the investigation going on. And he's going to order the police and he's going to issue a lot of warrants allowing the police to gather the evidence. And the investigating judge will be the one in charge of saying, now we have enough evidence to say that Martinez knew what he was doing and that he had a very important role in this whole trafficking case. And at this point, he's going to close the investigation and Jean-Luc Martinez is going to stand trial.
It's unfettered discretion, like the investigating judge who, just to be clear for our listeners, is sort of a cross between a court official and a prosecutor who kind of decides what cases are going to go to trial in the criminal system in France. Is there any check on that person? I mean, let's say that person is wrong. I mean, just has poor judgment about certain thresholds of evidence, or is it totally within an investigating judge's discretion, and if there's a mistake, it gets pushed to trial?
Well, Katie, you just put the finger on the weakness of the French judicial system, meaning, of course, the investigating judge is not alone in the investigation, but he has a lot of power and a lot of discretional power. Mm-hmm. So he will be the one eventually to decide that there is enough evidence. But in order to decide that there is enough evidence, he will be checking in with the prosecutor, also with the police, and he's going to relate to the French penal code, because we have very traditional penal code, and the investigation judge is here to make sure that the evidence the police found will match all the criteria.
So, Sarah, what are the charges against Mr. Martinez? I mean, what's he being accused of?
He's being accused of fraud and money laundering.
And how does that relate to these Egyptian antiquities that the Louvre Abu Dhabi purchased a few years ago?
Fraud is very broad in France, and it's any way of trafficking, either money or things or antiques or documents. Martinez is also charged with money laundering, which can happen by two ways. First, facilitating false justification of the origin of the property, or the process of purifying dirty money. So Martinez is charged with both, but it's very important to say right now that in France, he can be charged at the beginning of the investigation with those crimes, but the charges can change, and the investigating judge can point out that it won't be money laundering, but it might be fraud and theft or complicity of theft, and he might stand trial for fraud and another crime. It won't have to be the same charges as the ones pointed out by the investigation judge at the beginning of the investigation.
So that's totally within the discretion of the investigating judge to just change his or her mind, let's say in a year based on the evidence. And that's just the criminal defendant here, Martinez, just waits to see what the investigating judge decides.
It's up to the investigating judge and to the prosecutor, because the investigating judge will make sure that the police gathers all the evidence to constitute the crime. And once the prosecutor gets the case and gets all the evidence, he's going to check with the French penal code, and he's going to make sure that the charges will match an article or two articles of the French penal code.
So just to maybe ground this back to earth, because those are very, very broad sounding statutes you just read that seem like they could fit a variety of factual circumstance. The facts, as I understand them, are this art dealer, Christophe Kounicki, who is widely known as a Paris-based, I guess, antiquities dealer, sold a lot of objects to the Met, which we can talk about because the Met recently went through something very similar, although it didn't have to deal with a criminal procedure. He and his partner, Richard Semper, somehow were purchasing antiquities from this German dealer, Robin Dieb, who was purchasing the objects himself from looters or thieves in the Middle East who were pillaging objects during the Arab Spring. Is that right? Is that the chain of events here?
Exactly.
They were operating in the U.S. through Christophe Kounicki, and they were operating in Europe and the Louvre and the Met and other institutions. Even recently, with the high-profile looting that was going on, we're purchasing from Kounicki. So how does Martinez come into play here? He obviously oversees the purchase of these 5 objects from Kounicki for the Louvre Abu Dhabi. But what do we know about what he's accused of doing that is itself criminal versus just being duped by Kounicki, as everyone else was?
Well, at this point, we know that the police thinks that Martinez knew the documents provided by Kounicki were false documents, and that Martinez knew as a professional, as the director of the Louvre, that those false documents would be used to sell those antiquities to the Louvre Abu Dhabi.
And maybe was complicit in this himself? I mean, had some personal motivation to be part of this fraud? I mean, that seems like it's part of the case as well, that somehow he would be personally benefiting from the purchase of these objects, although I don't know how he did.
Well, he might very well have a personal interest in this crime. We don't know for sure that he has personal motive or that he took personal benefit from those sales. But since he's been charged with fraud and money laundering, we can definitely assume that the police has some evidence, maybe not enough at this point, to think that Martinez first knew that those documents were false, but also has gained some profit somehow and benefited from this crime.
And is that the money laundering aspect that I assume that for money laundering charges to be sustained against him, he would have had to either been involved in the sale of these objects knowing that they were looted and the liquidation of those assets, and or use the profits he received personally in some way?
Yes, definitely. For the money laundering to sustain, Martinez needs to know when he buys or sells the stolen pieces, or when he uses the stolen documents, he needs to know that those are false and or that the objects or antiques have been stolen.
Right. I think unlike our money laundering laws here, I think the laws in France can be a little bit broader, and that he doesn't actually have to use the proceeds or the liquidated proceeds, but just the fact that he is participating in the acquisition of these looted objects may make him subject to money laundering charges. Is that right?
Yes, that's correct, Steve. Money laundering is one of the broadest crimes in France.
Other than fraud, which is the other one he's charged with.
Exactly, other than fraud.
And so
I suspect that's the exact reason why Martinez has been charged with those two crimes.
Because it gives the investigating judge a lot of leeway to sort of fit the facts into those charges, depending on what he finds as the case develops.
Yes, the police is going to need a lot of warrants to search for evidence in general. And since the charges are very broad, the police will be able to search a lot of places and eventually find a lot of documents that are going to confirm or maybe deny that Martinez knew what he was doing and that this is a crime organization, because we really have to understand that Martinez is not the only one being charged with those crimes. And even though Deeb and Kuniki were released from custody, and right now they aren't under judicial supervision, there are still...
I thought Kuniki was under judicial supervision. I thought he was under house arrest.
No, he's not anymore. Right now, he's totally free.
That's weird because he's the one who everyone agrees is the real criminal.
Yeah, but I bet the police doesn't have enough evidence right now. And they might want to hear Kuniki as a witness during the investigation process.
I thought Deeb had been arrested.
Yeah, he was arrested. He was extradited, but then he was released after custody. But it doesn't mean that he won't be arrested later or that he might be put into custody later. The investigating judge has a lot of power as regard to the custody and to the arrest. So if at the end of the summer, for example, the police has enough evidence to show that Kuniki is definitely the person in charge of this antiques trafficking ring, then the police can arrest Kuniki. He can be put into custody. He might even go to prison before he stands trial.
Okay. And there are other participants that have been charged in France, isn't that right? I think in Auction House and other individuals.
Yeah, a lot of individuals were heard by the police, most of them as witnesses, because France has a very precise description of what a witness is. And you can have two types of witness. You can have just a regular witness, as you can have in any country. So the person will be heard from the police, and that's it. And you have what we call an assisted witness. And in this case, this witness has also the right to be heard by the police with an attorney of his choice. And it's most of the time the first step the prosecution and the investigating judge take before arresting this person or before putting this person into custody. Because, for example, an assisted witness can come freely to the police station, answer a lot of questions during 3 or 4 hours. And at the end, the police can go to the investigating judge, say, this is what we got from the witness, from the assisted witness. And the investigating judge and the prosecutor can decide that there is enough evidence to arrest this person and put this person into custody.
So I think Steve was referring to the fact that there are many, many people in this sort of suspected smuggling ring who are either being investigated, have been charged, have been brought in for questioning. So it's not just Martinez, but he's one of many people who the authorities in France have been targeting.
It's one of many because the charges are money laundering, but with an aggravated circumstance. Meaning, in this case, the aggravated circumstance is the organized gang crime. So it requires at least 3 people to constitute a gang ring in France and to sustain the crime of aggravated money laundering.
Right. I mean, I think what's so startling to us, of course, we keep forgetting maybe, or I do sometimes, that Mr. Martinez, who, by the way, denies any wrongdoing, I guess we should say that, was the former director of maybe the most preeminent art institution in the world. He was the director of the Louvre. And so he was also co-chaired the Bilateral Acquisitions Committee of the Louvre Abu Dhabi Museum. So this was a very, very sophisticated person. And I gather the Louvre itself has not been charged, right, Sarah?
No, the Louvre has not been charged at this point. And even more, the Louvre is now a third party, a civil third party in this case, meaning the Louvre will have access to the criminal case and to all the evidence that will be gathered by the police and by the prosecution. That's the only way for the Louvre to know what's in this case. Otherwise, the Louvre won't be able to claim a prejudice from this crime committed probably by Martinez and probably by the other people.
So Kuniki, his partner, and Robin Deeb, who are widely suspected of basically initiating and facilitating the trafficking of these Arab Spring looted objects, they are all awaiting trial in Paris as well, right?
Yes, they are awaiting trial, but we don't know right now what the charges will be for Kuniki, for Semper, or for Deeb. It might be the same as Martinez, probably money laundering and fraud also, or complicity of fraud, or complicity of money laundering. It might be all those charges as well.
Okay, so they are the core group with Martinez awaiting trial. And then there are a few other people that were detained at one point, right? There was the museum curator at the Louvre, who's the head of the Egyptian Antiquities Department. He was released. His name was Olivier Perdue, I think. And then there was a collector and another dealer who were brought in for questioning and maybe facing charges as well, I believe. And it's not clear to me, and maybe it's not clear to anyone except the investigating judge, how all these people interacted in this scheme. Sarah, do you have a sense of that, or is that all part of a closed file and we won't really know that until the trials start?
What we know at this point is that the museum curator called Vincent Rondeau and an Egyptologist, Olivier Perdue, were taken into custody and were further released. But as you said, once the investigating judge is in charge, everything is kept under seal and is secret. That's part of the investigation process in France. So if you're not a civil third party, you cannot have any access.
Like the Louvre here. So they have access to what's going on. Martinez has access. Presumably, Kuniki and Deeb have access, but the public will have no idea what the connection is between these people or what the facts are showing.
Yes, as you said, if you're accused of the crime, of course, for the defense to have those rights, Martinez will have access to the file. All the accused person have access to the file through their lawyers. And I really mean it, that the accused persons won't have access to the file, only their lawyers. And their lawyers are not really supposed to show the documents to their clients. I mean, they can relate to those documents. They can say to their clients, here's what the police gathered against you. So please explain and please help me out with your defense. But they're not supposed to show the file or any documents to their clients. And that's the same for the Louvre. I mean, the Louvre has become a third party in this case to make sure they are granted access to the file. So the Louvre councils have access to the file and they know what is supposedly a wrong or false document provided by Kuniki to Martinez and this crime ring. But that's it. I mean, otherwise the public won't definitely have access to the file and the public will know what the charges will be once these persons stand trial.
So, Steve, maybe it would be helpful for our listeners if you could remind everyone how the U.S. is very different than this process, right? I mean, how does a criminal defendant get charged here? And I mean, in some ways, it now seems to me to be a very enlightened, open system compared to what we're hearing from Sarah.
Yeah, sure. And I think the other thing that's interesting is Sarah's reminding me as she's talking about this notion that the lawyers get to see certain documents, but they're prohibited from sharing them with clients. And that aligns with a rule that they have in France that I became acquainted with and working on some cases there, which is that there are these lawyer-to-lawyer privileges, right? That lawyers can share things with other lawyers, and they're prohibited from sharing those things with their clients. And that's maybe a way that lawyers facilitate honest and open conversations among themselves. But I think for U.S.-style lawyers, that seems like a very strange concept, right? Because normally your loyalty is to your client, and so keeping things from your client just seems kind of odd to us. But yeah, in the U.S., of course, an investigation is usually conducted in the federal system through the U.S. Attorney's Office working with an impaneled grand jury. They do work in secret and they hear testimony and they look at documents. And then eventually, if there's probable cause to believe that a crime has been committed, the grand jury will return an indictment. And then, and only then, will the indictment be unsealed and it will be public. And that's when the individual is called to the court to either plead guilty or not guilty and then is ready to stand trial. What's different, and certainly to our ears in France, as Sarah's been describing it, is that there's a prosecutor kind of judge rolled into one, and that's the investigating judge. And while he or she is working with the prosecutor who ultimately takes the recommendations of the investigating judge and goes to trial with them, the power of this investigating judge is really quite broad and much broader than our prosecutors have, because prosecutors here, when they're investigating, even with a grand jury, have to go to a judge to get warrants, to get permission, and they can't just take someone into custody and hold them for 24 to 36 hours and question them. So it is a different process in France.
Yeah, and it's worth, I think, emphasizing the key differences to me are no one's arrested and no one's going to trial until this process with the grand jury, which is a selection of, regular people like any jury before a judge, is completed and the indictment is made public. So there's this requirement that the prosecutors, obviously in conjunction with the police or the FBI, bring their best case, prove it to neutral third-party citizens who say, yes, we're also convinced there's enough here. And the judge agrees, and then the defendant is brought into the criminal system and something heads to trial. And it sounds like in France that kind of early process doesn't really exist in the same way. And it kind of all happens at trial together.
Well, like you said, in the US, you have the indictment period. In France, we don't have the grand jury and we don't have the indictment. So basically, everything is secret and is really well kept secret during the investigation process. And once the investigating judge has finished his or her job, he sends his or her recommendations to the prosecution, and then the accused person is going to stand trial. And that's probably the only time during the criminal case in France when the public is going to know what the charges are against the person, what are the remedies, what the prosecution is looking for. Because even if you have the article in the French Penal Code, it says, for example, for aggravated money laundering, it can go up to 10 years of prison and a huge fine. But the jury doesn't have to sentence the accused person of 10 years. I mean, for some reason, the jury can decide that this person is going to face 6 years or 7 years. It doesn't have to be the maximum remedy.
Right. And so, I mean, of course, your point, Sarah, is that we're all speculating here because we don't know anything at this point about how the facts relate to these charges, which is frustrating, I think, as for American lawyers, because we want to understand how someone like Martinez can fit into this scheme, how the Louvre might have been involved. But is it fair to assume that his lawyers, at least, are coordinating with Kunicki's lawyers and Deeb's lawyers, that, you know, all the people who are sort of part of this big purchase for the Louvre and are thought to be involved in this scheme are sharing information and coordinating? Or what do you think is their level of interaction now?
Well, I think it's fair to say that there are two ways of doing this. First, as you said, they can coordinate their defense to make sure that the information that will get out will match what the other says. So, for example, we can assume that Kunicki's lawyers will speak to Martinez's lawyers, to Deeb's lawyers, and that the story that will be told by all the lawyers and by Kunicki himself, by Riva himself, and by Martinez himself will match somehow, and that it will be the same. The other option is that Kunicki's lawyers will want to reduce the remedy or the crime that his client is being accused of, and that he will share information with the police, with the investigating judge. And he might give them some information about what Martinez did or what Martinez said to somehow cut a deal with the prosecution, saying, well, I cooperated a lot with you. Now you have all evidence you need against Martinez. So then the prosecution can ask the jury during the trial to take into consideration
That cooperation, right?
Yeah, and everything that Kunicki said and did to facilitate the investigation process.
My guess is it's the opposite. I mean, if I was Martinez, I was the director of the Louvre, you know, I would say I was the victim of a huge fraud myself. You know, the Kunicki and Deeb are known to do this. They've sold looted objects to other institutions. You know, I wasn't aware of it. They gave me false documents I had no way of knowing. I mean, that's what I'm assuming that Martinez is going to say, and he would want to distance himself from them because they're such high-profile dealers.
Yeah, but here's the thing, and this is, I still come back to, the fact that he was the director of the Louvre. The Louvre Abu Dhabi issued a statement saying that it applies a strict international protocol for artworks entering the collection, and that protocol is strictly aligned with the 1970 UNESCO Convention. And just to take a step back again for a second, even though the 1970 UNESCO Convention puts forward in a way a date, 1970, even though it's of no particular legal significance, and we know that most major museums in the world, if you go and you try to donate a collection of cultural property, antiquities, to a museum, the first thing that they're going to look at is what is the provenance and how can we show that this object left its originating country before 1970. If we can't show that, museums are simply not going to take those objects except maybe under extraordinary circumstances. It just is somehow defies explanation or my own imagination to understand how a major museum can be looking at incredible Egyptian antiquities and not be able to do sufficient diligence to sort of establish that these are genuine or not genuine. And so I get we're speculating a little bit about what Martinez is likely to say, but I still have some doubts based upon the way the museums operate that there's a good explanation for this, and I'm waiting to hear it.
Well, the Louvre, interestingly, is not charged, right? So that is something perhaps we can address, but it's just Martinez in his individual capacity. But I think what he would say, which is what the Met Museum said in 2019 when it returned a sarcophagus, a very significant Egyptian antiquity, which was a sarcophagus it had itself purchased a few years earlier through Kuniki and Deeb. It just said they were provided with the right documentation that showed its legal export on a date that was not problematic. Names were provided, and provenance history was provided, and so they felt like they had the proof they needed. And that's the Metropolitan Museum of Art in New York. It's like if there's another museum in the world besides the Louvre that is as big and encyclopedic, the Met is one of them. And I think that's what Martinez will say too. I mean, that's what's been in the press, that he was, there were documents, they were just fake, but there were documents showing legal export on the right dates. And that's really the only process museums follow, is to ask for that documentation showing legal export before or after 1971 with differing requirements depending on the date.
No.
I'm suspicious too, but I mean, I don't know really what museums do beyond ask for those documents. And once they get them, are they hiring handwriting experts? I don't think so. And we have this example recently of the Met, which, wasn't criminally charged, but, voluntarily with great apology returned this object to Egypt in very similar circumstances. And actually, we know much more recently, the Manhattan District Attorney's Office has seized even more objects, Egyptian antiquities from the Met, that were also sold through Kuniki and Deeb. So it's an ongoing, unraveling saga. There'll probably be other museums involved as well at some point. And, they were all operating under, I guess, this ask for some basic documentation, get it, and that's enough.
Yeah.
Basically, the only thing that leaked a little bit from the police in some newspapers in France is that Kuniki provided the police with documents claiming the steel had been exported by a German Navy captain named Johannes Behrens in 1933. And that at some point in the process, an expert thought he never saw the name Johannes Behrens before. And that this was weird because he was a specialist of Egyptian antiquities and he never saw this name before. So he started doing a lot of research and turned out this name was false. I mean, Johannes Behrens was not a German Navy captain, and that the first document provided by Kuniki was actually false documents claiming ownership of the antiques. So this is how the story apparently started in Paris, with this expert going to the police and going to the director of the Louvre saying, this is kind of unnerving because Johannes Behrens is not a real person, and what you got for those Egyptian antiques seem to be false documents. And this is how everything started.
And that's very similar to what happened at the Met too. I mean, there were false documents showing good provenance. I think, what the choices are for these museums are, pretty sobering. And as Steve said, many of them, even these museums we're talking about, are much less likely to accept donations of antiquities now because they know that they do not have the capacity to run down their legal status. And that's for a few reasons. One is there's not an expert team of people at the Louvre or the Met who are trained in provenance research, who are experts in antiquities, who have access to every database necessary, for example, to look up who was in the German Navy in 1933. They just don't have that capacity, and they aren't using their resources to outsource it to other experts. So, and I don't know how reasonable it is to expect that museums are going to somehow build expert departments to accept donations or justify sales that can really dig down deep like that. I think much more likely is, and what we're seeing, Steve and I have seen this in our own practice, is just a reticence to accept these objects at all because they're too problematic. There's often no paperwork demonstrating when something was exported, if it was done a long time ago, or what the provenance trail was. And so it's just too risky, and they're not going to accept these gifts. They're not going to make these purchases as much anymore. And so they're going to avoid the problem entirely. Obviously, the sad thing about that is that there are going to be either legitimately exported or homeless antiquities that have been in collections in, let's say, the United States or France for a very long time, that are going to go unseen by anyone because the paperwork isn't there and museums aren't going to take them. And so, these works of great status and, that are worthy of study by experts are kind of going to stay in the dark because of these legal hurdles. But I don't know what the answer is to that. It just seems like there's no good, obvious answers for these institutions.
I think, it's interesting because I agree with what you're saying, but I also think some of these objects they're very significant pieces that were acquired for millions of dollars. And so the notion that there's no resources to do due diligence checks of the type that, we've certainly seen done in the art context it just strains credulity a little, at least to me. And it reminds me a little bit of even, when we've seen cases of fakes and forgeries in the art context, in the Knoedler cases, for example, where people, because they want to believe, you have a curator maybe who really, really wants these objects for whatever reason, are willing to accept provenance information that, when you look at it, you say, how could they have believed that, right? And sometimes people believe it because they want to believe it. And maybe that's what happened here, but I don't know.
It's probably some combination, right? You're not a handwriting expert or a paper dating expert, and you see a legitimate export document and it looks fine, and you also don't really want to ask more questions. So you have no red flags necessarily, but you also have no interest in looking for them. So I think that's also right, Steve. It's also the issue that, you have perhaps not the right chain of command at these museums making the decisions for the most part. You may have curators who really want the object for art historical reasons, but aren't lawyers, aren't compliance people, aren't necessarily trained to do this kind of due diligence, and they're not incentivized to. Of course, in the case of the Louvre, you have the director of the whole institution, who's also the French government's ambassador for cooperation on cultural heritage. That's a little harder because, how much higher in the chain are you going to go? But it is interesting to think about how to catch these issues in these institutions. Sarah, do you have any parting thoughts or predictions for how this case is going to go in Paris?
Well, I think it's fair to say that it's going to take many years for Martinez to stand trial. Because, as you said, it's not only Martinez, it's also many other people and a very large and famous auction house called Berger and Associates. Which is where
Kunicki worked.
Yeah, exactly. So I think it's fair to say that the police is not going to come up with all the evidence before a couple of years. And I really hope we're going to get all the information on this case. But as I said before, the investigation is secret in France. So it might turn out that in 5 years or so, the investigating judge is going to say, well, there is not enough evidence against Martinez or against Kunicki or the auction house. And Martinez didn't know those were false documents. They're probably going to try to charge him with any other offense or crime to make sure that this won't just remain a lost case and that Martinez won't be just free to go. But I think it's we can assume that it's going to take a solid couple of years before anything or anyone has the truth on this matter.
So we'll have you back then to talk about this again.
Thank you, Sarah, for joining us today. It was a real pleasure.
Thank you very much.
And that's it for today's podcast. Please subscribe to us wherever you get your podcasts and send us feedback at podcast@schalaw.com. And if you like what you hear, give us a 5-star rating. We are also featuring the original music of Chris Thompson. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
The information provided in this podcast is not intended to be a source of legal advice. You should not consider the information provided to be an invitation for an attorney-client relationship, should not rely on the information as legal advice for any purpose, and should always seek the legal advice of competent counsel in the relevant jurisdiction.